Welcome back. So let's get to our next conversation, which borders on the disputed delineation of Warri federal constituency. And in 2025, there were several engagements in the broadcast media with speakers from both sides, the Shekiri and Ijaw groups, disputing the INEC's delineation of Warri federal constituency, saying that it goes against the Supreme Court judgment of 2022, which ordered a fresh delineation exercise, which according to it had impacted negatively on the conduct of elections in polling units in Warri constituency in the past. And so both sides are saying that if INEC does not release the report of April 2025 on the exercise, that it may impact negatively on the coming elections in 2027. So let's get an insight into what the current state of things are ahead of 2027. And joining us now on the program for this conversation is Mr. Eric Omari, a lawyer. Mr. Omari, good morning and welcome to the Morning Brief.
Thank you so much for having me. It's my pleasure to be here again.
First of all, let's start with clarity over this report that ought to have been released by INEC. What are the expectations from this report, and will it resolve the disputed delineation that INEC had embarked upon in the past? Let's start with that.
Well, in the first place, I don't think that there is a disputed delineation as per se. What happened was that on the second day of December 2022, the Supreme Court of Nigeria gave a final judgment to the effect that INEC should carry out a fresh delineation of polling units and electoral wards all over the Warri federal constituency. And as a law-abiding agency, we expected that INEC will comply with that judgment. Yes, indeed, INEC called for a series of stakeholders meeting, did a field verification of the constituencies involved, then came up with an interim, what they call referred to as an interim report. The expectation was that after the submission, the presentation of the interim report to stakeholders, INEC will move to the final stage by releasing the final report so as to use it to conduct the 2027 election. But unfortunately, more than a year after that interim report was submitted, INEC has not been able to do that. Now, this is the issue. The issue here is that the Supreme Court in that judgment said the contention of those who went to court was that the electoral wards and units that were existing in the Warri federal constituency were not properly done. And the Supreme Court agreed with them and said, look, INEC, go back and do a fresh process, meaning start afresh. INEC has not completed that process. INEC has then gone ahead to release timetable for the conduct of the 2027 election. So the question is, without completing the fresh delineation of electoral wards and units, where are the wards and units that you will use in conducting the 2027 election in the Warri federal constituency? So that raises a fear in the constituency that if INEC does not complete this process, they may be de-emphasized from participating in the electoral process. So some of us have been wondering, what exactly is the problem? Why has INEC not concluded this process? On the 28th of September 2025, INEC Director of Voter Education and Publicity, one Victoria Eta-Mercy, stated that the delineation has been suspended, that it has been escalated to the Office of the National Security Advisor. Then on the 6th of February 2026, Abdulhai Zuru, one of the national commissioners, while addressing protesters from Warri, stated that they are consulting with the Office of the National Security Advisor. As a lawyer, I find that very strange, because under Section 160, subsection 1 of the 1999 Constitution, INEC is independent in the performance of its functions. It states clearly that INEC shall not take instruction from the president. So the question is, if INEC cannot take instructions from the president, therefore means that all positions under the executive, including the Office of the National Security Advisor, which is under the president, INEC ought not to take instruction from it. So it amounts to a legal absurdity for INEC, in violation of the provisions of Section 160, to say that they are waiting for the Office of the National Security Advisor to give them direction on how to implement a judgment of the Supreme Court. Again, that is also a violation of Section 287 of the Constitution. The Constitution says that once the Supreme Court delivers a judgment, all agencies of government, their only obligation is to enforce it. In this case, the Supreme Court specifically, in its December 2nd judgment, said, INEC, you are hereby compelled to carry out fresh delineation. So the issue is, why will INEC, having been compelled by the highest court in the land, still go ahead with seeking permission or to wait for direction from the Office of the National Security Advisor in order to implement a judgment of the Supreme Court? That is a legal absurdity. Then another dimension to the problem is selective implementation of judgment. Only a few days ago, INEC released a statement that they want to implement judgments of Federal High Court and in some cases Court of Appeal with respect to suppress constituencies. 11 in Kogi State, 4 in Delta, across the nation. The question is, the issue of suppressed constituency is about electoral representation. The issue of electoral polling units and wards that INEC Supreme Court asked them to conduct fresh delineation in Warri is about electoral representation.
Right.
Why would you go to the one of suppressed constituencies in Kogi and some other states, you want to implement that, but you don't want to implement the one that Supreme Court, the highest court, has asked you to do in Warri.
Right.
So the impression in Warri here is that INEC is being selective in its implementation of Supreme Court judgments of court. INEC ought not to be. In short, if there is any judgment that INEC ought to respect, it's a judgment of the Supreme Court. And this is further made more complex by the fact that we have a professor of law and a senior advocate of Nigeria as chairman of INEC. Therefore, stakeholders ought not to be agitating for INEC to comply with judgment. So, in effect, these are the issues.
All right.
The issue
so let me come in quickly here. So for full disclosure, so people understand the proper context, who do you represent in this case? Is it the Shakiri?
Well, I argued the case at the Supreme Court. I argued this case.
Yes. So which of the sides are you did you represent? So for full disclosure, so people understand.
I led the Honorable Judge Chimilimi and others who filed the case on behalf of themselves and the young people of Warri Federal Constituency.
Right. So we've had an Ijot chieftain also calling on the NSA to ensure that INEC completes the delineation. And you say that INEC doesn't have any business with the NSA, but we know that INEC does not work does not work in a bubble in that sense. It's not an island. For it to even conduct elections, INEC works with security agencies, works with transport unions, works with all sorts of people to ensure that the process goes smoothly. So are you saying, matter of fact, that you suspect interference, or don't you think that this is a normal procedure? If they're even going to conduct such, in that kind of atmosphere, you need all of the security advice that you can get.
No. Let us get the context very clear. When we say INEC collaborate with other agents of government, does not mean that INEC they need to take their approval. No. Under the Electoral Act and our Constitution, there is a scheme of work and responsibilities of different government. For example, if INEC is to conduct an election, they need security support. But that does not mean that they must get the approval of the National Security Advisor before they can do election.
So has INEC said that they are getting approval? I just want to be clear. Has INEC said they're trying to get approval from the NSA? Because I'm looking at all of the official statements from INEC, and there's nothing of such nature.
Hold on. I have just quoted on the 6th of February conversation by Abdullahi Zuru and that of 28th of September by Mrs. Victoria Mercy. You see, the context is this. In this context, the issue of national security advisors, advice or whatever does not arise. INEC has already done the field work. Where they are is that it is for them to release the final report, having taken representation from stakeholders after the interim report was submitted. At that point, they no longer need the Office of the National Security Advisor to give the final say. I have earlier quoted Section 160 of the 1999 Constitution. INEC, in doing its job, doesn't take direction from anybody. Yes, there may be collaboration, but that does not make their work to be subjected to the Office of the National Security Advisor. That's the point here. INEC to say that, look, they are waiting for the direction or advice of the National Security Advisor before they will release the delineation report is a violation of Section 160. And it has implication on
what were the exact words? Pardon me, what were the exact words of INEC regarding the NSA? Again, I'm looking at at least what we have officially, that statement which you referenced from Mrs. Victoria Etamesi. There is nothing of the NSA there, but you said there was a conversation afterwards. So what were the exact words here? So we're clear on
the consultation with the Office of the NSA. But the point I'm making is that INEC does not need that consultation or whatsoever approval before they implement a report or carry out their function. This function is their statutory responsibility. And the Constitution says they enjoy independence in the performance of their functions. The fact that some stakeholders may have raised issue doesn't mean that INEC will not do its responsibility. The point is this: there has never been any time where INEC carries out any political activity in Nigeria without objections here and there. INEC's responsibility is to look at those objections, do what it is expected to do under the law, and complete the process. But the meat of what I'm saying is that INEC has no excuse whatsoever not to complete the delineation or complete the implementation of the judgment of the Supreme Court in Honorable Judge Timinimi and others against INEC up to this moment, because without completing that process, it cannot conduct any election known to law in the Warri Federal constituency. And the people of the Warri Federal constituency has a right to fully participate in the electoral process. That's the point. So whatever excuse that, yes.
Now that has been, thrashed as much as possible. You said earlier that there is no dispute over the delineation, but many times last year we had quite a number of groups contested delineation that had been done, especially the Ishekiri groups, which said that it allotted more wards to the Ijaw group and that it specifically excludes them, underrepresents them in whatever elections that will be conducted subsequently. So do you deny that there was quite a lot of concern expressed particularly by the Ishekiri groups last year over the delineation?
Like I said earlier, in any electoral process, people are bound to express their dissatisfaction. Now, in this context, INEC first and foremost submitted a report and call it interim and asked stakeholders to make their input. What that simply implies is that INEC envisage that people will make input in response to their report. It wasn't only the Ishekiri groups. The young groups made their representation. The Urhobos made their representation. But the point is this: having taken this representation, INEC is under duty to look at them and come up with its final decision.
So is it perhaps...
It cannot hide under the umbrella...
Is it perhaps because of this contention...
groups not to continue or complete the process?
So is it perhaps because of this contention that INEC is delaying the release of the final report?
Well, it is for INEC to say that, but my own point is that INEC cannot hide under the umbrella of that contention to refuse to obey the final judgment of the Supreme Court. Whether contention or not, it is under an obligation. If there are issues raised by stakeholders, they have a duty to address those issues and come up with their final report in compliance with the order of the Supreme Court.
And so how do you propose that this will be resolved? Because there are concerns being raised by all groups now, not just the Ishekiri, Urhobo. We're reading in the reports that they're kicking against this and that it will impact negatively on the coming elections in Warri Federal constituency.
The resolution is very simple. Nobody, as to the best of my knowledge, I have been in court for these cases, I have been in stakeholders meeting. Nobody has said that the judgment of the court should not be obeyed. What some of people have said is, look, I think that INEC ought to have considered this, considered that. All these representations are before INEC. INEC has looked at these representations severally and haven't looked at them. It is now their responsibility, based on their criteria and the guidelines that came up with, to resolve these issues and come up with the final report. I will repeat again, INEC has no right whatsoever under our laws to hide under the umbrella of protest by stakeholders not to obey a judgment of the Supreme Court. the representation of groups have been done, look at those representation, address the ones that you can address in accordance with your rules, and come up with the final report. But under any other circumstances, it must come up with the report before the conduct of the 2027 election.
All right, Mr. Eric Umare, we thank you so much for coming on the program to bring perspective to these issues. Mr. Eric Umare is a lawyer representing the claimant in this suit between INEC
the appellant
and
at the Supreme Court.
The appellant at the Supreme Court. Thank you for coming on the program.
Thank you.